There is a renewed push by Hindu groups to reclaim the holy sites of Kashi and Mathura. As a first step, local courts have ordered commissioners to conduct surveys of the sites to determine if the mosques stand on temples raised by bigoted Mughal or other kings. The demands for darshan and the push to reacquire these sites have rattled secularists. They have thrown the rule book at the Hindu petitioners. They say that a 1991 law called the Places of Worship Act forbids any bid to change the status of a place of worship after August 15, 1947. Nevertheless, notably today, three-judge bench of the Supreme Court observed that under the law, any move to ascertain the religious character of a place of worship is not a violation of the 1991 Act. However, this particular issue has not been woven in to the order. This is what Justice Chandrachud, while hearing the Gyanvapi case, said yesterday in court. Hybrid nature of places of worship not unknown in India. Ascertainment of religious character of a place is not a violation. Ascertainment of religious character may not necessarily fall foul of Section 3 of the Places of Worship Act of 1991. While the Supreme Court has ordered some clarity, has offered rather some clarity, the Act is being challenged on several grounds. And let me quickly sum these grounds up for you viewers. The contention is that the Act was passed in Parliament in 1991, but denies a fundamental right to remedy to petitioners. And there are other reasons, viewers, that are listed. For example, that it offends the rights of Hindus, Jains, Buddhists, Sikhs to pray, profess and practice religion under Article 25. Infringes on the right of Hindus, Jains, Buddhists, Sikhs to manage, maintain, administer places of worship under Article 26. Deprives Hindus, Jains, Buddhists, Sikhs from owning religious properties belonging to the deity. Takes away the right of Hindus, Jains, Buddhists, Sikhs to take back their places of worship and property belonging to the deity. Deprives Hindus, Jains, Buddhists, Sikhs to take back places of worship connected to cultural heritage under Article 29. Restricts others from restoring the possession of places of worship but allows Muslims to claim under Section 107 of the Waqf Act. Violates doctrine of Hindu law that temple property is never lost even if it enjoyed by strangers for years, as deity is the embodiment of God and a juristic person. So this is the writ petition, viewers, that has been filed by Ashwini Upadhyay in the Supreme Court 2020. There are others, viewers, who call this entire legislation communal, and they have advanced certain reasons for it. Now, viewers, one of the reasons why there are many who argue in favor of this act is because it has stood the test of time. August 15, 1947, reasonable cutoff for independent India. The Supreme Court has said that the act is intrinsically related to secular states' obligations, and this was something that was mentioned in the Ayodhya judgment by the 5-judge bench. It also went on to state that untoward law and order situation, blanket claims are made could arise. So there is a whole host of reasons that were put forth. Now, viewers, the question that is being asked is whether righting historic wrongs can be considered an illegality, whether the act itself is illegal in some ways and ought to be struck down, as it basically militates against the basic structure. Let's try to get an honest conversation going on this. And in the spirit of converse, viewers, we have assembled some of the finest legal minds and public intellectuals. Ranjit Kumar, former Solicitor General of India, is here with us. Pinky Anand, former ASG also here with us. Senior advocate Nalin Kohli, national spokesperson of the BJP, but today we are hoping he wears the legal hat. Aryama Sundaram, senior lawyer, Supreme Court is with us. Aman Lekhi, former ASG. Sanjay Hegde, senior advocate and someone who's also involved in this particular matter. Dr. Anand Ranganathan, representing the intelligentsia. Let's open this up, viewers, and ask the most basic question. And I want to begin with Mr. Aryama Sundaram. Mr. Sundaram, where do you stand on this particular petition challenging the maintainability of this particular Act of Parliament?
Look, I believe that with the Ayodhya case and the decision of the Supreme Court in the Ayodhya case, an avenue or a vista was left open for knocking at the doors of a court to ask for recognition of one's religious attachment to a particular area. The fact of it is, I've said this once, I say it again, these kind of things are more socio-religious and more religio-political than purely legal. And the reason is this. You may have a constitution bench judgment which very clearly says that, look, this is an exception for Ayodhya, but so far as the rest are concerned, the Act will apply and the Act will be given effect too. But for a country who are extremely religious as people, where religion is, to use it very simply, a religion, whether of any religious persuasion, religious goes to the heart, the soul of an Indian. Now, they are not going to see, an Indian is not going to see the nuances of the Constitution bench judgment. The Indian is going to see the fact that in the case of Ayodhya, Ram Janmabhoomi, Rama's birthplace was protected, and a temple is to be built there. Ergo, if it's Krishna's birthplace, why not? If Shiva and his linga is meant to be there, why not? So you are going to have this knocking non-stop. And the answer to it has to be political. It cannot be placed at the court's door. The answer has to be political, what you're going to do with these. Don't forget that in South Africa, after apartheid came to an end, after the whole regime changed, they started going back into ownership of land for hundreds of years to see when the lands were first taken away. Now that was a political decision made. So far as India is concerned, a political decision was made through the Act of 1991. That Act has been challenged. But equally, that Act, should the government of the day want to amend the Act, repeal the Act, otherwise is also available. But so far as the court is concerned, the court is really walking on a very thin line. Because on the one hand, you have the Act which says you cannot change the religious place of worship. On the other hand, you have an order of the court which has directed an investigation and an inquiry to see whether there were Shivalingas there. And the question the court did put was, well, that is not prohibited to find out whether there were Shivalingas there. On the other side would be said, all right, if you do find out there's a Shivalinga there, then what is the consequence? The next step will be this, to which the court could very well say, we cannot predicate that the whole matter is pending before the district court, so go before the district court. And that in effect is what happened today. But the matter is far more basic as to what the government stand on this is, as to what the government of India feels. And that's why I said this is a socio-religio-political issue more than anything else. The question of secularism comes into play in preventing a person from offering worship. Secularism doesn't come into play in permitting someone else to also offer worship. Now that is the subtle difference again. So this is a highly debatable issue. There's a lot to be said on both sides, but I think what's most important is to see what the government is saying, the government of the day feels, because the government is expected to be reflecting voice of the people. At the same time, protecting Article 25, protecting secularism, protecting people of all faiths. That has to be taken care of. Okay. But like I said, I come from the south, and I know that down in the south of India, deep south of Tamil Nadu, we have a particular shrine which is both worshipped by Muslims and by Hindus. It is both a mosque and a temple. Now, that can coexist, but maybe that's utopian. So in which case, one has to practically look at this matter and see where we're heading and take a complete judgment, a complete decision on how to deal with these matters. Until that decision is taken, you're going to keep having problems like this. There's going to keep being uncertainty, unless with certainty it can be said, what is the status?
Okay, let me bring in Mr. Ranjit Kumar, former Solicitor General of India. He's also involved in this matter. Mr. Kumar, if you just read the Ayodhya judgment, there is a reference to this particular act of parliament. And there it emphasizes the secular traditions that it seeks to protect the state. Now I want to ask you, Mr. Kumar, I thought the very purpose of secularism as defined in this country was that the state should not be actually interfering in faiths or the expression of a faith, but just ensuring that there is no discrimination. This act on plain reading seems to not just discriminate, but also allows the state to meddle, interfere. In Article 25, 26, others which I have read out. Would you agree or would you disagree?
Well, I would like to put it a little differently, Rahul. First of all, I have appeared in the Ayodhya matter also for 42 days before the Constitution bench. And I appeared today in the Kashi Vishwanath Gyanvapi mosque case, which was listed today before the special bench on behalf of the plaintiffs who have filed the suit. You see, secularism only means that every religion must be respected and every religion must have its own space, so that there is in the fraternity of all the people that we are, we should live peacefully amongst ourselves irrespective of the religion. That, according to me, is secularism. Now, insofar as this case is concerned, the Act only says that you will not convert something or the character of something which is worshipped in one manner or by one religious denomination. But the Act does not say that a court cannot go into the question as to what is the character of that place of worship. What is being challenged and agitated in the suit in the Varanasi court, which was the subject matter of petition today, is the fact that whether this is a Hindu place of religious worship, because there was a shivling, this was destroyed by Aurangzeb some 500 years ago, and there a mosque was built, but yet the remains of that temple still exist, and therefore the character of the mosque, or whether it is a character of a temple, that character can still be examined whether it is there or not. Their place is not being converted. So therefore the prohibition is against conversion. That's the realm of this suit. So therefore one has to look at it from that angle, and this Act does not prohibit going into that question. In fact, the bench of the court also said that during the discussion or the debate in the court.
Yeah, see, I appreciate that point, and I think I sort of referred to it. But Mr. Kumar, I asked a larger question about the maintainability of this Act itself, whether it is good in law, to put it plainly.
No, well, the circumstances under which this Act came, we all know what happened. 89, 90, 91 riots, etc. were happening. It was in that context that this Act was brought into by the government of that day. Today, if the government feels that this Act is not necessary, that is for the government to decide. I don't want to comment on that. But the Act only says that please respect the sentiments of all and don't convert something which is in existence into something else.
The question is, why not? The question is, why not? They say that you shouldn't be writing the wrongs of history, how far back will you go? I say, for example, controversially, why not?
No, according to me, if historically something has been destroyed and that belonged to one religious denomination, that should be restored, because a historical wrong can always be corrected. But for that purpose, you will have to go into and examine the issue whether historically something happened in that manner. We all know that from ancient times, India, of course, has been a diverse civilization, but it has been predominantly Hindu from the very beginning. And we know about ancient temples, and we also know that we believe in Sanatan Dharma. Sanatan Dharma means idol worship. And therefore, temples of ancient times have existed and are existing even today.
So if there is that,
so therefore,
and even the Supreme Court today talked about these,
it ought to be corrected.
Yes, they talked about it ought to be corrected, for which this particular act needs to be struck down. That would stand to reason. Okay, now we haven't answered why, but at least we've got Mr. Ranjit Kumar to suggest that historical wrongs should be corrected, which means that till there is this so-called impediment, we may not be able to do so, because that's what is alluded to by those who say that, look, you are going to go up against this act. Now, I'm asking a more fundamental question. Let me bring in Pinky Anand and Dr. Ranganathan and Mr. Hegde, and of course, Aman Lekhi. Let me begin with you, Dr. Anand Ranganathan. You're not the lawyer on the panel, but as a layperson, do you have a problem with this act? If so, why?
Good evening, Rahul, and good evening to my fellow panelists. It's a real exalted panel of, I'm surrounded by 6 lawyers and I feel guilty already. So please pardon if I disagree. I disagree with my first 2 esteemed panelists already. I don't believe this is a religious social issue. This is entirely a legal issue. And I disagree with the earlier speaker about the definition of secularism. What he meant was pluralism, not secularism. But Rahul, to come back to this issue, and I have 3 or 4 points to make, and I really love this whole setup of Converse. It really gives a lot of gravitas to the issues, and people are discussing this, like the dust of thoughts, allowing the dust of thoughts to settle. Rahul, sadly, I have to say this, that history written by the victors is peddled by the vanquished, and we remain vanquished. To me, one of the most barbaric legislations ever enacted in India is the 1991 Places of Worship Act. But in 2019, the virtue signaling Supreme Court in its Ayodhya judgment willfully ratified this act that obligates maintaining all religious places as they were on August 15, 1947. Historical injustice of Kashi can now never be addressed unless Parliament overrides it. Rahul, a legal recourse to correct historical injustices cannot be denied in a democracy. And please, this is not a Hindu or a religious issue at all. I, as a Darwinian atheist, demand the abrogation of the Places of Worship Act. Rahul, if a mosque had been demolished by a Hindu king and a temple built on it, I, a kafir and an atheist for whom Islam sanctions death penalty, would have fought for the rights of Muslims to legally get back their mosque. I would have stood with them. Because to me, the mark of civilization is this unquenchable thirst to demand justice for your ancestors. Baki hai kya zindagi mein? To correct a historical wrong. For that exemplifies a continuity, an idea, a memory that can never be erased, that is worth fighting for and preserving. It makes justice greater than the sum of its parts. And that is why civilizations are not fleeting like empires. That is why, Rahul, history is a medicine, catharsis a cure. If an image could speak 1,000,000 words, it would be that of the Nandi, waiting patiently for 400 years for his Lord to emerge and for this historical injustice to be corrected. From Somnath to Kashi Vishwanath, these injustices have deliberately been made visible, as though to lionize the debasement, to celebrate the humiliation, if you will. And the irony is that the same people who have taught us this, drilled this self-loathing in us, these same people want others to fight historical injustices around the world. They condemn barbarians of the West hither to worship like the Confederacy generals, Rhodes, Churchill, Pizarro, Murray, Colston, Leopold. They celebrate their roads and buildings being renamed, their statues being brought down. But here in India, this same set eulogizes barbarians like Aurangzeb. Finally, Rahul, just 30 seconds. To show you the extent of the conceit, let me, if I may, read out to you a passage from the 2019 Ayodhya judgment where my lords exult and willfully ratify this act. Quote, "The Places of Worship Act imposes a bar on the institution of fresh suits or legal proceedings. The only exception other than Babri Masjid Ram Janambhoomi case is in the case of suits, appeals or proceedings pending at the commencement of the law on the ground that conversion of a place of worship had taken place after 15th August 1947. The Places of Worship Act is thus a legislative intervention which preserves non-retrogression as an essential feature of our secular values. The Places of Worship Act is intrinsically related to the obligations of a secular state. It reflects the commitment of India to the equality of all religions. Above all, this act is an affirmation of the solemn duty which was cast upon the state to feature and preserve the protect equality of all faiths as an essential constitutional value. The law speaks to our history and to the future of the nation," unquote. Really, I'm sorry, but this law airbrushes our history and it destroys our future.
Well, that's a passionate intervention. I just want to, on a point of law, just bring this out, and I'm happy to be corrected, Pinky Anand. Dr. Ranganathan says the virtue signaling Supreme Court willfully ratified this act. Now, we are told that this is a bit of a misnomer because it was not really called upon to provide any opinion on this act. It so happened that the judgment prior to this one, the Allahabad High Court judgment, referred to the act, and therefore the Supreme Court felt the need to reiterate its robustness or its capacity for maintaining the status quo and the reasons why, but did not really uphold the act in any which way. That now is happening. That challenge, where it will go into the merits of the act per se, will happen now after 2020 because of Mr. Upadhyay and other people's petitions. So if I'm not wrong, I just wanted to put out that fact, because otherwise it's going to be claimed by many petitioners to try and block surveys, etc., etc. So that's something I just wanted to park there. But I just want to ask you, Pinky Anand, look, you could take the sum and substance of what Dr. Ranganathan was saying and saying that how can you stop anyone from leading a study or an effort into righting an historical injustice? And that by its own virtue is an illegality because it takes away the right to remedy, which is written into the basic structure. Secondly, as just a lay, I'm not a lawyer, but I read this and I wonder that Ram Bhaks got their way, but not Shiv Bhaks and not Krishna Bhaks, if you were to talk about two other disputed sites. How is this even perpetuating a sense of equality? Within one community, forget the others.
Rahul, I think you voiced it rather well, being, even though you're a non-lawyer, but I think you're pretty near to achieving everything that takes a lawyer to go. So having said that, three things. One, on the first aspect of your putting out regarding the Place of Worship Act 1991, you're perfectly right. There was no reason for the Supreme Court and the Constitution bench to go into the Public Worship Act of Places 1991. The fact that they did, of course, is a matter of record, but neither was a constitutionality an issue, nor was it otherwise an issue, because Ayodhya and Ram Janmabhoomi were left out of the application of the act, and therefore there was no question of whether it should be applied, whether it should not be applied. So really speaking, you could in its own way take that as an arbiter which doesn't really count for much. And really speaking, the Supreme Court, right up till paragraph 102 of the judgment, doesn't hold that it is constitutional. It advocates the secular nature of the act and that there should not be historical wrong correction, but doesn't in any other manner uphold the act as we speak as lawyers. So the subject matter is wide open, and Ashwini Upadhyay's petition, as well as other petitions that have challenged, is something that has to be adjudicated upon. In fact, you take it like this, as you said, how can there be distinction between a community on the second question? Ram Bhakts and Shiv Bhakts and Krishna Bhakts, can there be such a difference? Now, the Public Worship of Places Act itself only, for example, excludes Ayodhya and Ram Janmabhoomi. It didn't exclude the other places of worship. So there is a big question mark that remains there. Secondly, by now I think we have well over reconfirmed that an act which prohibits judicial review. In fact, if you go to even the judgment of triple talaq in Shaira Bano, one of the issues that was taken up was the fact that it was a mechanism for divorce without any adjudicatory mechanism. So anyway, to come down to the entire situation at hand, you have to have a judicial remedy available. And finally, on the third part, and there are several more which you have also placed to some extent, the question is, something happened in 1199. There was partial destruction by Aurangzeb. The Shivling stands as on date. So the question of conversion is in any case not there. The act does not apply. But to my mind, the act definitely requires a look by the highest court of this country, which it is looking into, and notice has been issued on those petitions. And there is time and place for A, setting aside the act on various grounds, and B, there is an argument which is there and always will remain for correcting a historical wrong. Why should a historical wrong, if it is there and if there was also complete destruction and non-availability of the symbols, which in fact the studies have indicated, Kalash, the Trishul and various other part of the monuments which are there. And finally, Rahul, there is also the question whether the 1958 Act will apply, in which case it will be excluded from the application of the Worship of Public Places Act 1991.
Okay, Mr. Hegre, case for setting it aside, says Pinky Anand.
Some of your panelists spoke of historical wrongs. Now, if you're going to set aside every historical wrong, I know that you live in a place called Jorbagh across from a Muslim graveyard. Mr. Sundaram lives somewhere else, next to 100 Muslim graveyards. All that was Waqf land once upon a time. Waqfs are something which are dedicated to Allah in perpetuity. Somebody comes with the papers. Do they get to start digging under your house and say, okay, that is why we have what is called the law of limitation. Once there is something, somebody occupies land for a portion of 12 years or even 60 years against the government and continues to use it as an owner. The normal law cannot step in to dispossess him or take away his title. Now, as far as the 1991 Act goes, that was a call taken by Parliament in its time. Right now, Parliament can take a separate call. Why does Parliament not take that call? Why does it want the court to do its dirty work for it? Why does Parliament not say, look, 1991 Act stands repealed. All disputes are open for everybody to re-agitate in court if you can satisfy the law of limitation. The Parliament is not taking that call deliberately, and courts seem to be dragged in or seem to be rushing in, especially the local courts in Varanasi or Mathura or wherever, in the face of specific parliamentary legislation, saying, oh, we'll keep that legislation aside for the moment, we'll suspend it somewhere in between, we'll pretend it doesn't work, and we will go on merrily inquiring. Justice Chandrachud's observation is just an observation in court. It is not an order. It has not come out in the body of the order. But yes, it's a fine legal argument. A fine legal argument saying that, okay, we may question the religious character of a place, etc. But it still does not take away from the Act or the Civil Procedure Code, which says that a suit cannot go on if on the face of the pleadings it is barred by any provision of law. There is a law which prohibits it. This suit or any other suits cannot logically proceed to any conclusion of any change of ownership or possession as long as the act stays in force. So let Parliament take a call. Let Parliament say, damn, whatever are the consequences, damn, we are here. We have been elected twice. We will be elected a third time. This is our time. We are going to absolutely abolish the act and let this country loose into whatever kinds of claims there are on either side. If that be it. I frankly believe, you know, except for Mr. Ranjit Kumar, I think I've been the longest in the Supreme Court, and I've been I, as a young lawyer, saw the beginnings of the disputes in Ayodhya. I saw another very fine mind, that was Justice M.N. Venkatachalaya at that point of time. He come with the same kind of legalistic thinking, where he said, look, here is a government which says on solemn affidavit before us that nothing will happen to the structure. He believed that. And despite a solemn affidavit, the structure was brought down. And then it went into various other questions. And 30 years later, you have the 2019 judgment. What is happening today is something which will bedevil at least my son's generation, if not my grandson's generation. I do not know how long this country can afford this kind of going into the past, searching for wounds, continuing to maintain we are a wounded civilization, continually looking backwards for ancient grievances, and forgetting to look forward. Right. I don't think this is good for the country.
Hello?
One last thing and I'm done. I think there is some other...
Yes.
The last thing I'd like to say is, I just wanted to contrast Chief Justice Venkatachalaya with Chief Justice Bharucha, who was also faced with a similar kind of question that, you know, there will be all kinds of violence if you do not allow the state of Karnataka to release some people in order to get back Rajkumar, who was kidnapped.
Right.
And he just looked at us and said, if you can't govern by the law, quit. Consequently, the thing got solved in that year itself. Okay. I am looking at the approach of two Chief Justices, both very fine men, both men of utmost integrity. One possibly talked too much, thought it a bit too much, and consequently we ended up with something else 30 years down the line. One was, here is the law, I am going to enforce it, and no finesse.
Okay.
The problem ended within a year. I do hope, I really hope that there is somebody either on the judicial side or on the administration side who takes a firm line.
Okay, but Mr. Hegre, you know, I had assembled all the legal worthies to hold a legal argument. Yours is more political. No, you have obviously a valid point. Why doesn't the Parliament, you know, go ahead and repeal this? But for that, I would have needed 6 politicians here to have that discussion. I was hoping that you would give a critique in defense of the law.
Just 1 minute.
Yeah.
Sometimes it is said that judges rush in where legislators fear to tread.
Mr. Lekhi, do you have a defense for this law which is purely legalistic, contradicting the petitioners who are trying to have it scrapped through the courts? I will bring in Mr. Nalin in just a few moments on the larger issue, which is the political question about why Parliament is perhaps dithering, etc., etc. I'll bring him in on that. Plus, of course, Mr. Kohli has his own legal views. I will pick his mind on that too. But Mr. Lekhi, a legal reason why you believe that this law should not be scrapped?
Well, firstly, I would like to say that the fact that there have been historical injustices is undeniable, and the fact that Aurangzeb and people of his ilk were brutal and barbaric is a fact which is undisputed. I also agree that this is a legal and not just religious, socio-political issue. And because the two facts actually are admitted, I personally disagree with my other panelists that there is something atrociously wrong with the statute. And I say that for a reason. Firstly, as long as the law stands, the law is presumed to be valid, and we have to apply the law as it stands. That is absolutely fundamental to any law. Secondly, as far as the parliament is concerned, it is not unknown that the parliament can either destroy a right or deprive a remedy. There have been instances of that, and this is something which is again undisputed. Thirdly, as far as aspects are concerned, even in law generally, there are certain damages which are not deemed to result in injury. Now, what is the effect of it in the facts of this case? I'll deal with that. So it is not that every damage must always presume to result in injury. Fourthly, what is important here is the intertemporal principle, which is very important over here because a very emotive address and a very true address, which is the address of a pained man who is spot on as to the wrong which the civilization, the Hindu civilization, has suffered. But that said, notwithstanding the wrong, the fact that the wrong was committed should actually be the guide to ensure that a similar wrong is not repeated and the system is substituted. We cannot possibly have the same system continuing. That's the reason why we have as a break-off the year we became independent. Because on the day we became independent, we made law primary. And when law became primary, insofar as the rights are concerned, we determined the law as it stands. And while we will remain conscious of the historical wrongs, they will guide us to ensure that we do not repeat it. Now, as far as this aspect is concerned, what is relevant is that as the communities here are communities in the present generation. And unfortunately, and that is where I personally feel the Muslims have actually failed Hindus, and the Hindus in fact have aggravated the situation by not addressing this issue sensibly. The Muslims refuse to acknowledge the wrong, and the Hindus hurt that this acknowledgement is not being done right to enforce the right, which brings them into conflict. And conflict is not good for the country, because as far as the issue is concerned, resolution, a syncretic attitude and an eclectic approach is absolutely necessary. This approach is symbolized and epitomized by the statute, because what it says is keeping public good in mind, and public good will necessarily involve balancing of interests. And balancing of interests would mean adjustment. And adjustment would mean an absolute enforcement of right will be forbidden. So notwithstanding the fact that Hindus have been wronged, acknowledging that the wrong has in fact been committed. The act does not say that no wrong has been committed. It says that the wrong having been committed, the point is the system has been substituted, and because the system has been substituted, let there be closure, because perpetual flashpoints are not in the country's interest. What the act actually mandates is a sensible approach. And a sensible approach means you remain conscious of history. We don't remain in denial. We condemn people like Aurangzeb, and we don't go and celebrate Aurangzeb by going to his Maqbara, as some of the politicians have done, because that aggravates the situation. Much in the same manner, 3 or 4 people can't come and file a case and say convert the mosque into a mandir. If we are at each other's throats all the time, where will law be? What the law says is wrongs have been committed, a system is in place, and because the system is in place for the future, we are not going to relitigate or re-agitate these issues. If the law says so, it makes the public good primary. There is no violation of 25, there is no violation of 26, and there is no violation of 29, because these rights are not absolute, these rights are subject to public order. And if there is an approach that public order is going to be affected, anything which is going to affect this particular exercise must be stopped, and the purpose of law is that. So as far as this aspect is concerned, notwithstanding, and I don't deny the we suffer when we hear these issues. So what is the approach? The approach has necessarily to be, if there cannot be a reconciliation, the initiative has to come from the community. Because as said elsewhere, everything is not necessarily resolved through law or through legal process. As far as the approach is concerned, the approach has to be an approach of assimilation, wherein there is accommodation of competing interests and acknowledgement of what is actually troubling the communities. And until that is done, no amount of law, no amount of orders will ever bring about a resolution, because the element of discontent will continue. I personally feel that this element of discontent has to be addressed, and rather than look at the law, we have to look within to see what is it that we want to see as a future for this country.
Mr. Lekhi, quick counter to you. Most sensible approach you suggested. Wouldn't the most sensible approach be to use the system which advanced countries have evolved, which is the courts. Because in the Mathura matter, for example, in 1968, they came together, the two communities, and they agreed that, okay, you get to do what you want to do. But that consensus is broken. In fact, you talk about an element of discontent. If I don't have recourse to the law of the land to resolve my problem, I might do what Mr. Hegde says was done in 1992, which was jump on top of the 3 domes of the Babri Masjid and bring them down. So you're perpetuating, by blocking people access to the courts, you're perpetuating discontent, which might go out of hand, and then you're leaving it to the state to impose order, which can be fraught exercise in times of mass mobilizations. You'll have Jallianwala Baghs all over. I think Dr. Ranganathan is raising his hand. Yes, Dr.
Can I, with Mr. Lekhi's permission, can I please interject here, because I want to make the point, substantiate the point that you've made. Mr. Lekhi, can I please?
Yeah, of course. Yeah.
I'll respond to what Mr. Ranganathan says.
Yes.
Yes, thank you. Mr. Lekhi is an absolute legend. But here, if I may, he's a legal and I'm a legal raven. And if I may, he is looking more like a school teacher, a very good school teacher, than an excellent lawyer. And I'll explain to you why. You see, for Mr. Lekhi to say what he said, it's all very well in an ideal society where people respect each other and all religions think that all religions are equal and all. He has to understand what the fundamentals of one particular religion is. They are uncompromising. Please understand the ayats 4062. There is only one God. You cannot worship any other deity. You are forbidden this, that, whatever. In fact, I would say, what else is this but extreme provocation? That a faith, people belonging to a faith are continuing to worship for decades at a place that clearly has been built upon demolishing a Hindu temple. If tomorrow there was a temple built upon a demolished mosque and I was chanting Hanuman Chalisa, would I not feel that is a provocation for Muslims? That I am provocating Muslims? Of course I would. So this is a purely 200% legal matter. It cannot be settled between communities because we know the fundamentals of one particular community. And here, very briefly, I must agree with Mr. Hegde. The government is pusillanimous, they are scared, otherwise they would have abrogated this law. It doesn't need to go to the Supreme Court or any other court. Mr. Kohli will, of course, may disagree with me, the good Mr. Kohli, but I have to say this. The Congress had much more gumption. They overturned the Supreme Court not just once in Shah Bano, but twice. In 1959, Control of Temples Act, the Congress overturned it. The BJP doesn't even have the guts to overturn what the Congress overturned. So this is a matter that the Parliament should immediately abrogate the Place of Worship Act if they disagree.
I'll get Mr. Kohli in on that. Yes, Mr. Lekhi. Yes, go ahead.
Just one thing, for the very reason Mr. Ranganathan said, the very reason which he mentioned, that because they may be in religions provocative verses which actually dispose people to violence and oppose the syncretic attitude to create turmoil, you need law to prevail. For that very reason itself, because the literal understanding of any religion will lead only to violence and disarray. And the very argument which he is raising, this is not a school teacher, this is a realist. This is a pragmatist. This is a person having a core connect with the Indian polity. As far as this question is concerned, that is what is core to my submission, that the primacy of law will in some way and in every way prevail over religion. Now, if anyone, if a Muslim proceeds to act on that particular verse to in some way kill Hindus, law will intervene. And Islam will not be a defense. Much in the same manner as a Hindu cannot in any way interfere with the mosque, as long as it is a mosque and as long as the law stands. All I am saying is, as long as the law remains, the law will prevail. And any precedent which in any way undermines the law will have nothing but danger for this particular country. And more so because as a community, we are virtually at each other's throats all the time. And until we actually civilize ourselves in a way to understand with restraint and deal with restraint, we cannot in any way compromise with the law, and I think the law must necessarily prevail.
Okay, well, you know, the Babri Masjid dispute told us both things. You also had the law where you should not have had a demolition, but you had a demolition. The laws were there to prevent the demolitions, they happened. Then you had a law to punish the demolitions, and you know the outcome of that. And then you had a law, of course, that was passed there was a judgment that was passed, and the law is now being upheld in a very peaceful manner, and you might have a mandir constructed on a disputed property, and hopefully everyone has expected the outcome. But I just want to bring in Mr. Kohli. Mr. Kohli, the question to you, two accounts. Number one, do you believe that this law should be struck down? If so, why isn't the BJP taking the first step in that direction?
So, Rahul, it's a very nice panel, and I have to thank you to bring so many respected people together. In fact, several of my senior colleagues, I hold them in very good stead and have a warm relationship with them. The beauty of this discussion is it only shows and confirms we are a functioning democracy. We've had all sorts of views in a very, very civilized manner, and that's how a discussion should be. So let's approach some of these arguments. The fact of the matter is that this is, as far as I've understood it, and Ranjit Kumar sir can probably add to it, this is not a suit which is on a land title. As Sanjay was trying to say, it's barred by limitation or something. This is more in the nature of a declaration, as I've gathered from the media, I'm not in the case myself, which is about the right to worship in that place, within which the Varanasi court has passed an order, and we know what's happened thereafter in the Supreme Court, and we know the orders passed thereafter. Now this brings us to a fundamental question. At one end is the argument of secularism. Now secularism itself is an argument that has so many facets. The word secularism, or the word secular rather, was introduced in the preamble by the 42nd Amendment in 1976. So it didn't start in 1950. So that's also how it shows an evolution. Society, Parliament in its wisdom, whatever be the circumstances, as in the 1991 Act, chose to legislate on something. But does that mean that people can't go to courts? People can't have a right to go to court and put out what they feel and angst about? That's a daily job. And that's how it happens. There'll be two parties, multiple parties will go to the court, and the court is a good place for it to take place. Even the views that you've heard on your panel will perhaps take place in a civilized manner, and everyone has a full opportunity to put it out there. The second question is, can Parliament abrogate this law? Can it amend it? That is true for any law. How can it be stopped or said that Parliament can't change a law or even abrogate it? I mean, the First Amendment to the Constitution is in 51. You had over 100 amendments. In fact, I just gave the example of the word secular. That happened in the 42nd Amendment. So that's part of the normal process. There will be a law in a context. 1991 was a context. Some will argue the BJP even walked out of the Parliament and did not participate in the debate. But nevertheless, the process was followed, and that is a law. Now, can that lead to a situation that that law can't be amended? Or any law, can it not be amended? Of course it can be amended. But that is a right to be considered at an appropriate time. At the same time, can courts be said that they can't hear a matter of an angst for a person, a society, an organization? The organization before the Supreme Court is for the Muslim side. It's an organization. They felt the need. Invoked their right to be before the court, and they've got an order. In that order, both sides have been protected till the final issues are decided by the Varanasi court, now a district judge, as the order of Justice Chandrachud and Justice Suryakant and Justice Narasimha have gone out to put out. So let's come to the larger issue. I think courts are also a decent place for these arguments to take place. This is not, as Sanjay puts it, and I'll beg to differ on him completely, that, Parliament is trying to pass off its work to the courts. Certainly not. Parliament will do its work, as will the courts. And I don't agree with this, that it's a fight of one or the other. On the contrary, perhaps this might be the best way for these issues to be discussed, rather than it in an emotive atmosphere, looking at it as a political thing rather than a larger issue which has legal connotations. And that's how I would approach it. There are legal arguments both sides. Those sides will have a full opportunity to go further. Some are talking of a historical wrong on this panel, and reflected outside too. Some say that there should be a cut-off date. That cut-off date, whether it is to be 47 or not. There's another part of that argument. If something is founded on a historical wrong, should it be ignored if there is no reconciliation, as Aman Lekhiji is also pointing out? So these are larger questions. So in all of that context, perhaps what is before the court and the way it's going forward is probably one of the best ways to think about it in today's context.
Okay, well, Mr. Lekhi's line stuck out, and I'm going to paraphrase that. What is going to be now tested is whether Parliament can actually destroy a right or deny a remedy. That's really what's going to be tested. And we'll close this conversation here this evening. Thank you very much for being a part of it. I know it was lengthy and perhaps all of you didn't get all the time to speak, but I think whatever was said will have an impression on the viewer. Thank you very much, gentlemen. Thank you very much.